Okay, let's get going. Stand for the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, well, welcome to the regular meeting of the Zoning Board of Appeals for March 18th, 2025. We've got two matters before the ZBA today, but before we get to that, we've got to review the minutes from the prior meeting. Has anyone had a chance to review them, and are there any comments or revisions or proposals? Have a motion to approve?
Move to approve.
Second. So moved. Minutes are approved. On to the next topic. This is the application for variance from the landscape open space requirements for 23 Hidden Ridge Drive.
Mr. Chairman, before we begin, I know there are a couple of new members on the Zoning Board of Appeal, and I wondered if I might be able to give them an overview of how they
Certainly.
to evaluate these applications in light of our zoning ordinance. The Zoning Board of Appeal is the finder of fact in this case. This means that the board is to review the packets, the letter, and the presentation. It can also take into account the letters that were sent on both of these matters to the board, and it has to make specific findings of facts for to meet the standard of practical difficulty. Those standards are found in our zoning ordinance and are pulled from the Michigan Zoning Enabling Act, the MZEA. So there's some proposed motions before you. Those motions can be altered in any way, both for and against. Any relevant facts that you hear either in your packets that you reviewed, that you hear during this proceeding, or any other relevant fact from our zoning ordinance that you think will make a decision one way or another, I encourage you to put that on the record and include it as part of the motion. If there are any questions at any time, I'm more than happy to answer any questions from a legal standpoint or regarding the zoning ordinance. Are there any questions at this time? All right, thank you, Mr. Chairman. Sorry for the interruption.
No, thank you very much. Appreciate that. Okay, let's hear from the city engineer. I'm sorry, the planning. You're wearing many hats today, Eric.
Good afternoon, Mr. Chair and members of the Zoning Board. My name is Eric Peach. I'm with Giffords Webster, the city's planning consultant. I know there's some new faces here, so if I go too fast or miss any information, please feel free to slow me down or ask any questions. But we did have 23 Hidden Ridge Drive before the ZBA, I believe in September of last year. So this item was tabled for additional information to be provided and considered well, let me just go through here. So this is the A2 zoning district. We're located on the west side of Hidden Ridge Drive here. Woodward is just off to the left side of your screen. This is the A2 zoning district, so the A2 standards apply to these particular lots that are shaded in green. And this is just an aerial showing the different developments within the subdivision and the subject site highlighted in black. And then just the zoomed in version, you can see that the lot is essentially built out. There's the primary home with a entrance and exit off of the street, and then an existing pool and pool terrace, and then an existing quite large and significant impact from an existing tennis court in the backyard. So typically what we like to do when we first receive projects is to kind of take a snapshot of what the yard determination is for a property. So what you would do is identify what the front yard is by drawing a line that's parallel to the property line along the street. And so that's this red line here. Everything in front of the house is considered the front yard. Everything on either side of the house is side yard in yellow. And then further behind the house in orange here, this is the rear yard. And so typically the ordinance is set up or established where a lot of your accessory structures are allowed within the rear yard. Once you hit the side yard shown here in yellow, then that's a lot of the times where planning commission consideration and approval is required. But in this case, a lot of what's on the property is existing. As you can see, it's within the rear yard. But what happened was there was some work that was done prematurely, and so this essentially was an as-built survey review, meaning that whatever the changes that were made prior to permits being pulled, our review was done against that as-built survey. So moving forward, to kind of just explain the process, we review the ordinance standards against the property, and so everything that you see here in these tables, this is the cabana accessory building, the pergola accessory building. We walk through each of the proposed or existing items to identify whether or not it complies with the ordinance standards, and as you can see here, these items do. So then we get further along to the tennis court. As you may have noticed in those aerials, it's an existing tennis court, but in fact, it's an existing non-compliance, meaning that per our analysis, it encroaches within the minimum setbacks of the property. So while it's existing, it's non-complying with the ordinance standards. So we just identify that on here so that if there is any proposed changes to it, we would have to address whether or not a variance would be required, or if they're removing portions of it, that would bring it further into compliance. So that's the purpose of going through the tables as such. And then the location of the tennis court, it's allowed to be built in the non-required rear yard, non-required side yard. The non-required just means that it's outside of the setbacks. But as you can see here, for the rear yard, we've identified it within the rear yard's setback, so that it, again, is an existing non-conforming structure. The pool is existing, but they did make modifications to that. The pool fence is being left as is, so there is a pool fence on the property which also acts as a perimeter fence, and that's not changing, and it's going to be left as is. They are proposing new pool equipment, which is within the non-required side yard, which is permissible so long as it receives approval from the building official upon inspection. And then the biggest problem that we ran into with this parcel, as with many parcels in this subdivision that are built out, the landscaped open space becomes an issue. And so within the A2 zoning district, each lot is required to have 80% open space. So in other words, you're allowed to build up to 20% of lot coverage on the parcel. So what we found was, as existing, prior to receiving the plans for permit review, the lot had a 59.9% open space. They did make some improvements to that, mainly the reduction in the patio space that surrounds the pool, and that resulted in an increase in their open space up to 60.74%, so just under a percentage point. I believe that amounts to about 500 and some square feet of reduced coverage. So they're improving the existing nonconformity, but because they're removing the patio space, they're putting some of it back, and so that improvement of the takeaway is what triggers the Zoning Board of Appeals to address a variance request. So doing a side-by-side comparison, this is the existing coverage of the lot here. This was when the plans were provided to us for review. And then what they're proposing to do is over here. And if you just provide your focus through the center of the property, this is where primarily the changes are taking place here. So this is what was existing. You can see the shape of the pool is of a certain size in blue here, surrounded by green, which is the pool terrace. And then over here, what they're proposing to change is a slight increase of the size of the pool, but a significant reduction once calculated. There's a significant reduction in the green area, which helps to improve the overall lot coverage and the overall open space that is provided on the property. It doesn't get them into compliance of the open space, but those are the types of changes that we need to analyze to bring before the Zoning Board of Appeals for consideration and consideration of approvals. So as an existing nonconformities, there's a section within the ordinance. I briefly explained that, where a variance isn't required if you're an existing nonconformity in terms of lot coverage, if you remove the coverage. But it's because some of that patio space was removed and they rebuilt it. What's highlighted in blue is the section of the ordinance that states that you can't just remove it and then replace it, you have to remove it in order for it to move forward with building permits without a variance request. So then just to get a little bit more detailed with the existing nonconformities, the terrace existing is shown in green. There's the square footage here, about 3,000 square feet. And if you look over to what they're proposing, it's about 1,400 square feet. So it's, again, a significant reduction. But what counterbalances that is the pool, roughly 1,000 square feet, and then 1,100 square feet. They are proposing new accessory buildings, that being a cabana and a pergola. Those are considered accessory buildings. There was a third building over in this location that has since been removed just because the amount of accessory building was going far beyond what the ordinance permits. Also, if you look over here at the proposed cabana of about 720 square feet, the as-built survey showed a slight encroachment here, so the applicant is going to make the adjustment for setback compliance along the east property line there. And then this is just a photo. This was back in October when we did a site visit showing the pool that's under construction. This will be the reduction of the pool terrace surrounding the pool adjacent to the home. And then this was the second pergola, which I believe has since been removed. And then this one is the one that's on the proposed site plan. And this is taken from the vantage point of the cabana against the east property line. So looking further to the right side of the photo is where the existing tennis court would be. So as I mentioned before, this is how the fence is laid out. There's a fence surrounding the tennis court with two segments that tie into the house in the side yards here. But again, that's not changing, so there's no consideration from the ZBA regarding that. And then just, excuse me, in terms of screening, because the improvements are within the rear yard behind the house, the ordinance doesn't require screening per se. But as you can see here in green, this is existing coverage of landscaping on the site and at the perimeter of the site. And just looking at some more detail. In fact, I want to stand corrected. I'm not sure if the pergola has been removed. The second one, I haven't been to the property since these photos were taken, but the applicant's here and they can confirm the status of everything today. And then this is just a picture showing the cabana, which is here on the east side of the pool. And again, they did make the corrections that demonstrate compliance of the setbacks. And then there was some information that we received from an adjacent property owner to the southwest, which would be this property owner here, who had concerns and questions about this water feature. I think it was referenced as a waterfall, but I don't have any information regarding it being specific to a waterfall. But it is an existing feature that's here, whether it's a koi pond or just a natural spring. It's an existing condition next to the tennis court. You can kind of see the faint layout of it here, but it does show up on the survey, and they are proposing no changes to that, so I don't know if there's any additional concerns. I think the last time that the city engineer had discussed it, there was no major concerns, but it is in close proximity, as you can see, to the property line of the neighbor who has brought it to light for discussion. So with that, that concludes my presentation. Again, this was before you back in September. We don't have information about any variances that were granted in the past. That was some of the research that we wanted to do, but none was found with the city records. So there's no indication of how certain things were permitted in the past. And what's before you today is just found to be an existing condition, the improvements that were made without a permit, and for us to analyze that against the standards of the ordinance, just to kind of take a snapshot of what types of overages there are, and if those would be acceptable to the ZBA for relief from the standards of the zoning code. Yes, sir.
Eric, the last time we addressed this particular piece of property, there were issues outstanding with the city. Have those all been resolved to the satisfaction of the city?
I'll defer to the...
Yes, so at the last time that this was before the ZBA, there was an outstanding bench warrant stemming from the fact that these improvements that you see, including the pergolas as well as the cabanas, really all the work was started without getting the requisite permits. So that has been taken care of. There is no longer a bench warrant. All fines have been taken care of. And this is according to the prosecutor for the city. So at this time, there's nothing further on that front. I believe there's a stop work order on the property as well, to prevent continuation of work without the needed variances. So that's where we are as of now.
Had they continued to work after the stop work order was issued?
Not
to your knowledge?
Not to my knowledge. I believe Ms. Burton also provided a memorandum to the ZBA, kind of giving an overview of Hidden Ridge as a neighborhood, some other variances which have been permitted, as well as an overview of the open space standard when that was implemented, and whether deviations have been permitted in that neighborhood from the open space. Are there any other questions from members of the board?
Yeah, I got one. So the improvements that were the subject of litigation, those have not been, to your knowledge, worked on, right? Since
the stop work order was issued, and these tickets were issued and prosecuted, to my knowledge, they have not been worked on.
And there's been no suggestion that they're going to be revised or reduced in footprint or modified in anywhere, that they're just going to be built out as proposed? Is that the understanding?
That's the proposal. So these items were constructed without obviously variances and needed permits. They will be completed to plan as before the board if they get the variances.
Does that include the tennis court?
The tennis court is not, it is pre-existing non-conforming. So the tennis court is, interestingly, and I'll defer to Eric, but it's what is causing the landscape open space issue, quite frankly. However, it's pre-existing non-conforming, meaning it's not subject to ZBA review right now. My understanding is, and I think the applicant is here, they purchased the property with that tennis court in existence, and they just made modifications to the pool cabana area. So those items, because of the tennis court, those items are causing the landscape open space issue, if that makes sense.
Yes.
All right. Is there anything else that I can help with?
I do want to piggyback off of something Alana mentioned, which was a good point, was the existing nonconformities. These lots, unfortunately, within the subdivision, if you draw your attention to the bottom part of the screen here, these lots are impacted by an access easement. So it's not a public street that's dedicated, where there's a property on one side of the street separated by a street with a property on the opposite side of the street, when in fact the two properties on opposite sides of the street, they meet at the center line over on top of the easement, or the easement's on top of the lots. So the pavement of the road is calculated into the lot coverage, unfortunately, for these types of lots. So that further decreases the open space. And so that's just how these parcels are in existence. It's to no fault of the property owner, but it is one other element that we have to take into consideration when doing the analysis for open space. Yes, sir?
Eric, do you know how much that would contribute back towards the percentage if you calculated the road out? And
I think I have it on my markup. You can see here, we did calculate it to be about
2,800?
Yeah.
20 something?
I think it's 2,900.
2974.
Yeah. So it's a significant chunk.
Percentage-wise, what is that?
Gets you to 61 and a half.
All right, so it's minuscule.
Yeah, I mean, it will impact just when you get down to the details of everything, but you know, ultimately, it's just to call that out as a unique feature of the parcel.
Eric, I have a question. You showed kind of a partial picture of the so-called tennis court. From this picture, it looks like it could fit 2 tennis courts in there, the size of it. Is it more than a tennis court? Is it a basketball court? Is it a sports court?
From what I observed, it's a tennis court. It's just a large footprint tennis court.
And it looks overgrown now. Is it, has it been used, does it look like it's been used at all, or?
It does look overgrown and unkempt. So whether or not there's plans to resurface it, at this time, it's just considered existing non-conforming as a surface. But the applicant's here that can express what.
I know that's not part of our review, but if that disappeared, what would their percentages look like?
They would comply,
They would?
yes.
Okay.
Is the water feature, if I can ask the water feature, does it have a pump? Is it electrical? Does it circulate, or is it just a dammed up, just a static pond?
Right, I don't have a whole lot of details or information on that, whether city engineer shaking her head no. Stephen, do you have any information on the?
I think there's a circulation pump, a small pond just to keep the water moving and circulating, so you don't have insects breeding, things like that.
No,
I don't think
waterfall or no, because I think, wasn't there
There's no
a,
cascading walls or giant waterfall feature.
It was not in the plans in terms of anything being proposed to be done to it. So it wasn't really known about until actually visiting the property because, again, it's very faint on the survey. So until you actually go and see it on the property, it's kind of just hidden off to the side. So.
But wasn't that the major issue by the neighbor?
Yeah, the neighbor did speak and express that there was concerns with just water flow or, whether it fills up. And I think they even had mentioned that it does impact them during high rains.
Right, and flooding issues on
Right.
the adjacent property.
Mm-hmm.
Eric, before the applicant made all these improvements without a permit, did the property meet the LOS?
No, so that's the point of making this determination that it's an existing non-conforming with the landscaped open space,
So not just the tennis court, but everything, the cabana, the pergola, all the improvements, if you take those out, was the property still not in compliance?
if you take those out,
still not compliant?
here we go. So this gives you 80% is what's required for open space. So before the pool, before the cabana and the pergola.
But you said you analyzed this as an as-built, so it was already subject to all the improvements. Did you do the analysis without the improvements?
Yes, and so that's 59.9. So that would be this side of the screen. That's this, 59.9. So
It's actually slightly better now.
it's coming, if you focus on this area, the pool and the pool terrace, the modifications to this area is where the change occurs. So the reduction in the pool terrace increases the open space, but the expansion of the pool and the placement of the two pink pergola and cabana structure, that's what balances out to just a slight
Yeah.
improvement to the open space. And again, those are compared here, 59, and it bumps it up to 60%.
So the picture on the left was without any kind of improvements, just it was as is when they bought it.
Correct.
Okay.
Yes.
Thank you. Do you have any other questions of the planner? No. All right, are you done with your
Yeah.
presentation?
Yes, sir.
All right, can we hear from the engineer?
So the last time we met, one of the items that we did ask the applicant to do was to add some stormwater management onto the site. So especially when they're adding accessory structures, additional hard surfaces in the rear, we ask that they add some stormwater management best practices to their property in order to maintain the water on their property before it leaves and affects neighboring areas. So I just wanted to point to what the applicant has done and is proposing to do. So the rear of the home is back here. The items highlighted in yellow are some stormwater improvements. So this area here is a French drain, so an area that is meant to hold some of the water as it runs off the hard surface. And then they're also proposing a leaching basin in this area again, to hold the water, let it infiltrate into the ground in an attempt to keep water on the property before it leaves. This area is some existing storm sewer that they have that currently connects to a storm catch basin that is in the roadway that will still be maintained. So that is something that they have added since the last time that we met. Happy to answer questions.
So you're satisfied with the solutions that they presented?
We are. This falls in line with what we require of applicants to do on properties.
Any other questions for the engineer? Thank you. Anyone from the audience like to, well, I guess we should hear from the applicant. Applicant want to make a presentation?
Are you going to speak? I can, I'm buying some room on the neighbor on this side of the.
Well, are you the applicant or the neighbor?
No, I'm the neighbor.
Okay, is the applicant
Yeah,
here?
I'm the applicant.
All right, why don't you make,
Sorry, I didn't hear what you,
no, I'm
I thought
sorry.
you were asking for the audience. So, I'm Stephen Bonamy on behalf of the contractor and the homeowner of 23 Hidden Ridge. As mentioned, one of the biggest concerns at the last meeting was the site drainage. We have since updated the plans to show how the prior drainage worked, and in addition, we added a leaching basin and French drain system, which will contain a large amount of the water on site and reduce the amount of water that previously ran to the existing manhole, which then ties into the neighborhood stormwater system. We feel the variance is justified based on that the proposed plan actually is a reduction in hardscape than what previously existed, and it greatly improves the drainage on site. There's a commonality between the site and the surrounding homes on the site that also exceed the open space requirement. The scope of work is not excessive and has been designed to maximize the open space while maintaining the functionality of the yard. There has been, to comment on some of the comments that I've already mentioned, there's been no work on the site since the contractor received the stop work order, other than general site maintenance and cleaning up. There was some, at the last meeting, there were some concerns about drainage or water flow that was going to the neighbor's property. So there was some minor grading and then just site cleanup that was done. In regards to the structures, there's no structures have been removed at this time, but obviously they will be removed in accordance with the new plan. And the tennis court is 10.1%. The proposed right now is 60.744. So even if the tennis court is removed completely, it's still not going to comply with open space.
What's the homeowner's plans for that tennis court? They gonna
I
fix it up or?
think just to maintain it kind of as it is. Obviously, since the backyard's been, in this kind of state of unrest here for a while, so it's been overgrown by vegetation, but it would be cleaned and maintained. I don't think there's any plan to remove it or to resurface it other than, general maintenance on a tennis court.
You mentioned no structures have been removed.
Correct.
There was one pergola. Is the agreement with the applicant that is going to go away, or
Yes.
is that not an agreement?
So there's one cabana structure that's it's actually, right now it's placed a little bit further back here. So that structure is going to move so it is in compliance here. And then there's one pergola structure here that is existing and would stay. And currently there's another pergola that's right here that is existing that would be removed.
Is that all consistent with the tickets that were resolved in the district court? Are you aware of?
Yeah, as far as, I think it's kind of independent, but what we're proposing today meets the ordinance and is compliant with everything that we've discussed with the township engineer. And
So part of the, maybe I should have asked Eric, is in the representations, the fencing to remain, is that part of this application? No, even though it's depicted on the proposed.
Because fences are an ordinance standard within the zoning code, we just want to review for the standards of this particular fence. It was found that the existing fence is not going to change. So what our concern would be for is if there's any improvements to the side yard fence, which would require planning commission approval.
And there was none?
As of now, there's no plans to do anything with the fence, and I think it's noted in the review letter that if there is, that it would be anticipated that will go before the planning commission.
Is that your understanding?
yes.
Elena, what specifically will lift the stop work order?
Getting the proper variances, which will allow them to get the required permits, and then they can continue to work per plan.
Does the stop work order prohibit them removing structures that, in an effort of good faith for the neighbors to see that there's
At this
some
time,
movement in the direction of where they're going, or that's not allowed either?
right now, there's
No
no work
work.
on the site. But obviously, you know, depending on what happens here, they can get demolition permits, any required permits to remove the structure that's not supposed to be there, or any other structures that aren't supposed to be there.
Any other questions of the applicant? Thank you. Anybody from the audience would like to comment on this application?
May I?
Sure.
Bobby Saloon,
Would your name and your address?
Bobby Saloon, 11 Heather Ridge, on the next door property. My only thing is concern is when you guys are calling it pre-existing, that is actually not, I don't know where that pre-existing came from. I think it's pre-existing when they start working, not before they bought it. Because I can tell you for a fact that that water thing was not there. I've been living there since 2013, and that was built recently. So when they classified as pre-existing, last time we were here, they said there was no permit for any of this stuff. They can't find it. So the definition of pre-existing is basically we're taking the word of the previous contractor to say that that was pre-existing.
Well,
So
when you
we're
say,
proposing it as an improvement, but we don't know really what was the pre-existing, because I can tell you for a fact that water thing was not there.
okay, let me understand what you mean by water thing. You mean the proposed drainage?
No, the water
Oh,
flow,
pond,
the pond,
Creek.
you know.
Oh, I see, okay.
Yeah, that was not there, you know.
That koi pond? Or the so-called koi pond?
Yeah, like the pond there on the side or whatever it is, waterfall, you know, or whatever it is. That was only been there for about a year and a half, something, you know, since they bought the property. So the definition of pre-existing is we're all starting from the wrong concept of pre-existing because we don't know what the pre-existing. So that's really the problem that we have. So everything is new, not pre-existing, because you guys have no permit for anything that was there before.
And believe me, the city understands that, at least I think we do. My interpretation of pre-existing is when it got to the city. They bought the property, they did all the work without permits, they didn't seek permission, they just did it. The city caught them, took them to court, there was back and forth, the city spent a lot of money litigating this. It was ultimately resolved with some fines and maybe dismissals. And so the as-built is defined, in my understanding, is as the city found it already built without permission. And that probably includes that pond. Okay,
Correct.
so that's my understanding of the
But
as-built.
then you guys are basing at least what the presentation was, that this is an improvement from the pre-existing. The pre-existing was all done illegally, so you cannot improve on an illegal thing that was done. And then you claim that you did an improvement. You know, that's my only issue here.
Well, I think we're saying the same thing. I mean, when they did these improvements without a permit, whether they did them all at one time or did some before others, what's currently existing now was never done without a permit. And now they're seeking to, through litigation, and then this process, redress that, and then go forward with modifying what was built, taking some things out, modifying others to the proposed plan. That's my understanding.
And I appreciate, you explaining this, but my point is very, very simple, is you built something without a permit. And then, from the tone of the presentation, my understanding was that they're recommending that this is an improvement from the thing that you built. But what you built was not even legal to start with. So that improvement comparison should not be even there in the presentation because you're not improving, because I don't know what it was before. I can tell you, I've been living there for a long time. This is not an improvement.
Right. Well, and it may be the definition of what's improving the property and what's not improving it. Improving it is just building something on the dirt, right? That's an improvement from vacant land.
which was built illegal.
Which was built illegally, no question.
Were you the homeowner that sent the letter in mentioning a waterfall?
One of them, yes. I think
Yeah.
it was one of them.
We were just told that there was a recirculating pump on this. Are you claiming there's something other than that?
No, but what I'm saying is, this thing is only about 10 feet from my property.
Right.
Is there an easel for this? This is not pre-existing. This
Right,
was
no,
new.
agreed on that. I'm just wondering, is there a fountain or a waterfall or something like that? What,
Looked
is
like a
it
water-
something you hear or?
No, it looked like a waterfall, and my question was three-pronged here. One, is this is too close to my property, should not be allowed. You know, it's 10, 12 feet from my property. Number two is if it's gonna be waterfall, then what are we gonna do about the noise? And if it's not a waterfall, what are we gonna do about the mosquito, if it's a stagnant water? So that was the three questions in regard to this.
Okay.
Let me ask the city attorney, is this
Yes.
water feature, was that involved in the litigation?
No, it is not. I do think we're getting there's a couple of different issues going on in this property. And I think that the neighbor, I'm sorry, I didn't quite catch your name, but I think his concerns are very valid about, setbacks regarding the water feature. And it's good that the city is, hearing those concerns and can investigate, the permitting on that particular feature. But what the Zoning Board of Appeals is here to kind of determine is whether the standard for practical difficulty is met for open space, and that really only involves the proposed improvements on the center of the property.
Yeah.
Yeah,
The
so
hard
that's,
surfaces.
yes, correct.
And we're not, at this hearing, with this presentation, this application, this screening is not at issue, right? That's not
Correct.
something that can be
Screening is not a-
conditioned on the approval.
Correct. In this case, screening is not, I think Eric touched on that during his presentation. There are, of course, issues on, the stop work orders. That's sort of in one bucket over here, them doing improvements, but we're in a different bucket on the practical difficulty question, if that makes sense. Are there any other questions?
I have a question for the applicant's representative. Do you know when this feature was built?
Not to my knowledge, no. It's hard to see from, I came in after the fact, after the work was done. So it's hard to see from aerials because there's a lot of tree growth in that, but I know the homeowner and the contractor, they want to resolve the issue. So if there was any concerns of drainage from the pond, that would all be resolved, and there can be an overflow that would go into the leaching basin. So if there was a large amount of rainfall or something and there is a berm with evergreens along the property line, so there would be no water flowing into the neighbor's property.
Leo, was that part of any analysis from engineering that pond wasn't serving any purpose?
What feeds that pond? Where does the water come from?
Mr. Chair, speaking from the city, this may have required a landscape or minor grading permit, I don't know, but we will certainly look into it as a separate issue.
Okay, thank you. Yes, sir.
I'm Jim Travis, I'm president of the Homeowners Association. I live across the street. Is there any, I'd like to address this to the city attorney, is there any body of law or regulation or scripture that the Homeowners Association and Dr. Saloon that we can appeal to stop this water feature and eliminate it?
To eliminate the water feature? I hesitate to answer that question. I'm the city's attorney. I can't really give legal advice to the homeowners association. What I do know is that the city manager has indicated that he's going to look into the permitting history that can all be FOIA'd. And if there is something that was done improperly or illegally, it can certainly be addressed via the proper ticketing procedure. Off the top of my head, we're governed by the NCEA and city ordinances. I'm not as familiar with what legal remedies, if any, would be available to the homeowners association, and I am not comfortable giving advice on that.
Can you build a material significant large water feature next door to someone else's property in this city?
I will take a look at that from an ordinance perspective. As far as any deed restrictions, you would, I think what Ron is saying is that you should check with your homeowners association to see if there's any deed restrictions or any sort of water feature being built on the property. But we as a city have to deal with the ordinances, so I would be happy to take a look at this from the ordinances. Yep.
But neither of you is aware at the moment of any reason why a resident cannot build a significant water feature close to the next door neighbor's lot line.
That is not what we're saying. We're saying that obviously anything which is built on the property has to conform with ordinance standards, has to conform with setback requirements. There are many standards which have to be met for any sort of significant feature. We're not saying that it is compliant. We're saying that this hearing is not addressing the water feature. And your original question was, is there any body of law that a homeowner?
Right.
I'm not sure of a separate body of law outside of,
Okay.
ordinances, deed
Ordinance that
restrictions.
passed things and so forth.
Yes.
So how do we in Dr. Saloom uncover the existence of any such things?
So you can check deed restrictions. You can check our ordinances. Obviously, the city manager is also going to be doing that and looking into this. The ordinances are also available on Movie Code. They're online as well, so anyone can look at the ordinances, as is the MZEA. That's what we reference. That's our Bible. So
Are they scannable?
I will be happy to talk with you about this after the meeting.
Fine.
Yes.
Thank you. Anybody else from the audience want to comment on this application?
Mr. Chairman, may I propose it?
Does anybody else from the board have any further comments on this application?
I don't.
I'd like to entertain a motion.
I would like to move to approve a variance from section 24-196 for a variance from the landscaped open space requirement to permit a landscaped open space of 60.74% in lieu of the required 80%. The applicant has demonstrated practical difficulty for the following reasons. One, strict compliance with the requirements would unreasonably prevent or severely limit the owner from improving the existing site. Subject property is an existing nonconformity insofar as it deviates from the open space requirement by 20%. The proposed alterations would reduce the open space deficit down to 19.24%, thereby reducing the existing nonconformity and permitting needed updates and improvements to the site. Two, the variance would do substantial justice to the property owner as well as other property owners, as it would permit a home consistent with other homes in the neighborhood. The total amount of open space will slightly improve with the proposed improvements to the site, and the proposed improvements to the pool, fire pit, pergola, and cabana are in line with accessory structures and improvements common to other homes in the neighborhood. Three, the plight of the property owner is due to the uniqueness of the property. This property is existing non-conforming when it comes to the landscaped open space requirement, a circumstance not common to other homes or new builds within the city. Therefore, any improvement or work would likely violate the landscaped open space requirements. The proposed improvements here will reduce the overall violation of the landscaped open space provision. Four, the proponent's problem is not self-created in that the property is inherently non-compliant when it comes to landscaped open space. Five, the granting of the variance will not adversely affect the purposes or objectives of the master plan. The purpose of the master plan in residential areas is to allow homeowners the opportunity to improve the property while minimizing impact on the neighbors.
Thank you. Do you have a second?
Second.
All in favor, say aye.
Aye.
Any opposed?
No.
Abstain. I didn't hear the history until tonight, so.
Okay, well, motion carries. Thank you. All right, the next matter for the ZBA, we'll consider the request from the property owner at 355 Pine Ridge Drive for a variance from the minimum side yard setbacks and the calculated side yard setbacks to construct a new home, and a variance to locate mechanical equipment in the required side yard. There Eric.
Okay, thank you, Mr. Chair. Our next item for consideration is 355 Pine Ridge Drive. There are 7 separate variances that are before you today. Those are outlined on the first page of the review letter dated today's date. We made an update and a modification, a clarification point that item number 5, variance to allow an accessory building, that being the detached garage, to be located in the front yard. I'll get into the details a little bit later. The initial variance review that was provided to you only included 6 variances, but upon further detailed inspection, the front yard accessory building, that being the garage, is included in this request as well. So on to the parcel. This is a parcel that's located in the A2 zoning district. On the south side of the property line is the Bloomfield Hills Country Club. And on the north side is the A3 zoning district, and as you can see, surrounding properties are also A2. And this is a zoomed out aerial view. As you can see, the cul-de-sac of Pine Ridge has a driveway access that is within the property, provides access to the parcel to the west, which is under common ownership. So both parcels, 16 and 17, are owned by the same owner. And what they're proposing today is to develop the parcel highlighted in black for a new home. And this is a little bit clearer of a aerial picture showing the property. So in reviewing this application, we wanted to get information on how the lot was established. And so here, shown on the left side of the screen, is lot 16 and lot 17 as it was originally platted back in 1978 as part of the Echo Ridge subdivision. And from our research, it's been determined that a current survey that is done matches the layout of the platted lots. So this was the original configuration. There was no reconfiguration of the lots. Lot 16 is an existing nonconformity in the sense that it does meet the minimum lot size of 1.5 acres in the A2 zoning district, but in fact does not meet the minimum lot width. So the way that a lot width is determined is by measuring the distance of the width of the lot from its setback. So roughly in this location where these 2 arrowheads are, that distance is approximately 164 feet. What's required of the lot is 175. So we also made that analysis down here in the southern leg of the lot. This width dimension is approximately 109 feet. So it's quite significantly less wide than what the A2 district would typically would require if this was to be subdivided or a lot divided further from, say, if lot 17 and 16 were together. So applying the yard determination graphic again, we start with the front yard being taken from where there's public street frontage or just street frontage. This lot is unique, as you can see, with a lot of the focus of development towards the south, towards the golf course. But applying the yard determination as best to our ability per the ordinance would establish the front yard line here where the house is proposed. So everything that you see in green would be considered the front yard. You'd have your front yard setback determined here in pink, and then side yard setbacks, or the side property line setbacks here in pink. And then carrying through the rest of the yard determination, you have the rear yard in orange at the bottom, and then the 2 right and left sides in yellow. And as you can clearly see in this depiction, in order to develop a home with golf course views, the main area of focus would be in line with the existing homes in the subdivision at approximately this plane. And so that's what the applicant is opting to do. This is just to zoom in a little bit further. We had initially met with this applicant early last year, so I think we're a little bit beyond our first meetings with them to discuss the different options that the proposed development could potentially have. That being, of course, opportunities to develop further north within the interior of the lot. But what's before you today is for the golf course oriented views of the proposed site. So that takes into consideration some serious constraints in regards to the minimum setbacks. So you'd focus your attention on the pink layout here. So the first challenge was to get a design that meets the minimum setback standards, and that again is what's outlined in pink. So after a few iterations, a few meetings with the applicant, some modifications to the design of the home, they were able to fit it within the minimum setbacks. So there is no concern in regards to the primary structure encroaching on either side setback of the property. What comes into play further, as some of you may know, is the algebraic setback analysis, which takes into consideration the height of a building along a property line as well as the length of a line. And so when you apply that formula to the east and the west sides of the proposed structure, it alters the setback requirement based on the length of the line, the length of the home, and the height of the home. So because they're right up against the setback lines, chances are that if you have a higher home, that it's going to fail that analysis. And so even though that this is a one-story home, the analysis that we did determined that there are some non-compliance of the algebraic setback, and I'll try and explain that as best I can as we go through the review here. So this is just an overall snapshot of the different variances that are before you today. So starting with one, just in brief, the proposed home is outlined or shaded in gray, and then from there is a carport. You can kind of make out the shape of a car here. So this is a carport where the extension of the roof is supported by this little red column here, and there's a picture that I can show that'll give you a better representation of that. But because that column is supporting the carport structure within the 34-foot setback, that's the first variance that's under consideration. If that column went away and this was engineered to be a carport that could support itself without the column, then that variance request would go away. Number 2 and number 3 are together, so we want to reorient. North is looking to the left. So this is the west side of the property where setback analysis was done roughly where this red line is shown, and then a second one that was performed here, and that's the algebraic setback where you plug in the height of the house and the length of the house to determine whether or not that those portions of the building are set back far enough from the west property line. And it's those two areas that do not meet the outcome of the formula. And so that's where your next two variances are to be considered. So number 4, there's only one variance along the east property line. The house along the setback does not comply with the algebraic setback as well. So when we drew additional lines through the rest of the structure, because it's a flat roof and the length is not changing, then it's essentially just at some point behind this red line, you're going to get to a point where the building does comply because there's no increase in height and it's not expanding in length any longer than it currently is. So at some point behind this line, the house complies. And so we identify the variant as location number 4 here. Moving on from the primary structure, we go over here to the detached garage, which is an accessory building. As you recall, the front yard is highlighted in green, and so this is where the garage structure is. Accessory buildings are not permitted in front yards. If the building was attached to the house, they would all function as one, and that requirement would go away. And so, of course, we did look into attaching the detached garage to the house, but that just worsened the scenario with the algebraic setback because it made the line longer when applied to the house plus the garage. So the applicant opted to make a detachment to the garage. Previous iterations showed that the garage was a 2-car garage, but what's before you today is for a 3-car garage, but unfortunately there's an encroachment into the setback. So that's where variance 6 comes from. So we did discuss with the applicant who's here and can provide more details about the reasons why the footprint of the garage expanded. There's limitations to storage space within the home itself. And so the information that I have is that third garage space, which is marked here in red, is essentially for storage. But again, the applicant's here who can elaborate on that. And then lastly, focus over here, these three little red areas. These are 2 air conditioning units and then a generator unit. Mechanical equipment is allowed to be in the side yard. So again, the yellow area right here, but not within the setback. So this pink line is the boundary to where mechanical equipment is permitted to be. So because it encroaches into the minimum setback, that's the 7th variance that's before you today. So definitely a challenging lot to have met with the applicant on, to go through the different iterations, discussing potential hardships in designing this home. The next few slides will just walk through again more of the details of the different variance requests. Again, this is number 1. It's this column that supports the carport. You can see here this is the driveway on this color depiction that supports the overhead carport. And so that's approximately here within the setback. The house has a unique feature in that the roof eaves extend into the minimum setback, and the ordinance does address that standard. And there's a certain percentage that you're allowed to overhang into the setback, and so we did do that analysis. The overhang is about 4 feet, and we determined that that is an acceptable overhead encroachment into the setback. So there's no issue with the roof eaves. Number 2 and number 3, these are the west algebraic setbacks. Again, the building meets the side setbacks, so there's no encroachment into the minimum setbacks that are established by the ordinance. It's just when the analysis for test line, we call them test lines when we do an analysis for the algebraic setback. So test line 2 is on this portion of the building, which is here. So this red line matches this segment of the building, number 2, and it's the height of this portion and the length of the line in regards to its proximity to that west property line, that the equation or the formula for the algebraic setback makes the determination whether or not the height and length is too close to the property line or if it's sufficient enough to pass the formula, to pass the analysis. I know it's kind of a tricky concept to wrap your mind around, so if there's any questions as we go, please feel free to ask. But because you can see it's a flat roofed structure, there's no increase in height as you go further into the building. So when you make measurements along this segment of the building, there's no increase in the height and there's no further increase in length of the line. So at some point, we determine that if the requirement of the number 2 setback is 31.98 feet, what's provided is 26, that's where the red line is drawn. At 31.98 feet, that's where there'll be compliance. So a portion of this structure complies. But what happens is at the point of number 3, the line elongates, it gets longer here, and there's a slight increase in the height of the house. So with those variables taken into consideration for the next analysis, number 3, we want to see if that line meets the setback, the outcome of the formula, but unfortunately it does not. So variance 3 requires 45.75 foot in terms of its setback, but it's only 40 feet, 40.25 feet. So it's acknowledging that this portion of the building, despite it meeting the 26 foot minimum setback, by applying the algebraic setback, it does not meet that analysis. And yes, sir.
Could you go back to the original drawing and show us again what's on either side of these lots, or of this lot?
Like the.
So as you look at the west side, what's there now on the west side that it is encroaching on?
So,
is that the golf course or?
No, so good question. So to orient ourselves, north is up, south is down. The subject site is the pink. This is the original plat. So lot 17 has a current house on it. That's this yellow area here.
And that's not being demolished, right?
No,
Okay.
no. So the two parcels are under common ownership, but there's no change in lot configuration. So lot 17, which has a home and an occupant, also owns lot 16, which the separation of the lot, the legal description being that this is lot 16, it's being looked at as its own development for a new single-family home. So they're not tied together in any sense. The existing home that you see here up against the property line is approximately 2.5 feet from the property line. So there's concern as to, well, how did that ever get approved? And so I don't have any information of how that house was permitted. The plat is from 1978. And according to the parcel maps for Oakland County, it looks as though the house first appeared in aerial images sometime in the 80s. So I don't have any information of how the existing house is in such close proximity to the adjacent property. But as we go through some of the additional analysis in terms of the items that are in the setback, we'll have more conversation on that as we go. So we apply the same analysis for the algebraic setback along the east side of the property. Again, this is where the setback requirement is 34 feet. And again, the house structure itself meets that standard. We also have to incorporate in, because the carport is attached to the house, that means that the analysis for the length of the line has to also travel through the carport. So unfortunately, when you do the analysis for this red line, the requirement is for a 44.53 foot setback, but what's provided is 34.33. So roughly, if for this house to be approved against this property line, it's required to be set back an additional 10 feet by the way it's designed here, even though it meets the minimum standard, or the alternative is to either shorten the line or reduce the height. But as you can see, it's a one-story building with kind of a walkout area down below. So those factors, they may have been taken into consideration when designing the home, but ultimately we got to the point where this is the design that best fits the property by honoring the minimum setbacks.
Eric, if I could you go back? The elevation that you see on there, the east elevation, is that actual elevation or is that as graded to build the walkout?
So I think there's minimum changes to the grade. So Leah can speak to that after my presentation, but I think there's minimum changes to the grade here to the extent that it does not exceed the 2-foot maximum allowance. So they're within compliance of the grading ordinance to stay within 2 feet of cuts and fills. So that's essentially what's there now with some minor grading alterations. Okay. So variance items 6 and 7, the 5 represents the detached accessory building, that being the detached garage, and then 6 represents the red shaded area of that building that encroaches into the minimum setback. So that distance is about 22 feet, whereas its requirement is 34 feet. And then lastly, oops, I forgot to change the number. This should be a 7. So these units, we looked at multiple locations, or I should say the applicant had looked at multiple locations to put the mechanical equipment. On the south side of the property is more of a patio area that is on the ground facing the golf course. So there's a lot of access points there that just don't, that wouldn't accommodate any mechanical equipment like this. If it was placed on the opposite side of the house, it would be in close proximity to the existing home. The existing home down here. And then on the north side of the property, that's where there's a lot of the interaction with the driveway and pedestrian access to the garage and to the home. So kind of the focus was to see what would work here. did receive some opposition from the neighbor on this side of the lot, and so after receiving that information, concerns in regards to the mechanical equipment, we met with the applicant again to discuss any options, but we just reaffirmed that the alternative locations around the building just didn't make as much sense as the location here. But again, that's what's before the zoning board to kind of hash out those details and to hear from the adjacent neighbor. But essentially what we looked at when those concerns came in was to get a dimension for how far those units would be from the location of the existing home, which is shaded here. So by scaling the drawing and making measurements, we get a dimension of approximately 68 feet from the closest mechanical unit, that being this AC unit, to the closest point of the house is about 68 feet. So when performing an analysis based on setback requirements for the A2 district, this red dash line represents the 32-foot setback, as well as this red dash line, represents the 34-foot setback. So when these side setbacks are placed side by side, that separation distance required by the ordinance is about 68 feet. And so we just wanted to gauge whether or not this was something that could be close enough for the ZBA to entertain the location of these units meeting the spirit of the ordinance based on how the setbacks are established within the ordinance. So that's the purpose of giving a visual depiction of how we took the approach that this location of the mechanical equipment would be at least reasonable for the ZBA to consider.
Eric,
Sorry.
I'm sorry.
Where's the mechanical equipment for the other house?
Well, so we don't have a full understanding of where the mechanical equipment is for the other house, but it was observed that there is an AC unit outside this wall here. But that's all that we observed. So whether or not there's an issue with that is kind of beside the point.
That question.
Sure.
I'm Charlene Handelman. I live at 2081 West Valley Road. My generator is on the other side. My generator is by my garage.
Ma'am, we'll get to public comment in a moment, okay?
No, but you wanted to know where my generator was.
Well, we've walked out and we've seen where the air conditioning, the question was outside the window there. Eric, how tall is the screening wall around the mechanicals, and what's it composed of?
We do have a, let me see. So here is the representation of the walls. You can see there's various heights. They're labeled as landscaped walls, so I believe they're within the 3 feet. These here.
Do they completely cover the mechanicals, the generator, the AC?
No, so they're not intended as a screening mechanism per se. They do offer some, noise mitigation, I would imagine. But in terms of the height, the standard that the ordinance requires is for any wall that immediately surrounds the units, for that to be at least as tall. I believe it's actually a foot taller than the units themselves. So the applicant shows additional screening enhancements in that location. So you have a wall here, a landscape wall, with, I believe these are the European hornbeam that abuts the property line for the first layer of screening, the wall, and then bushes, which we need some specifics on those, and then some trees that will be planted with the intention to further screen the walls that are around the lower walls that are around the units.
Are you aware, though, that there's any reason why the walls screening the mechanicals couldn't be raised, and would that impede its function?
I believe they could be. I don't know if the applicant wants to address that when they speak, but there could be more immediate screening in terms of wall height that could be increased for those.
So, let me just ask, so the I guess I'll call it a block wall, is it a foot along the side of the AC units, or is it
this here
18 inches? Just to give me perspective.
I think because of the change in the grading, it may change in height, but I don't think it's any higher than 3 feet.
Okay.
looks like it's about a foot, foot and a half.
Yeah.
It looks like
Okay.
it's about 1
Yeah.
foot, foot and a half on the very.
The limitation
small-
is 3, so.
So I mean,
yeah,
is that just an example of a wall, or is that the proposed height? I mean, presumably it can be bigger, right? It can be taller without affecting its function?
Yeah, they can go up to 3 feet and still be within ordinance standards.
So the main focus when the concern for proximity of those units within the setback had arisen was to do as much as possible for screening of those units in relation to its adjacency to the existing neighbor to the east. So that's what the attempt is to show here on this landscaped plan. The ZBA, as a condition of approval, could require additional screening enhancements, but there is a noise ordinance. There's standards to the noise ordinance. I don't have specifics to that, but these units must comply with certain noise decibels that are established at the property line. And so all of that would have to be in compliance in addition to the concerns that were raised here.
Can this board approve a wall that's higher than 3 feet, even though it's not, within the city ordinance?
Technically, yes.
So we could make it 4 feet if we wanted to.
Well, so I'd have to see what the ordinance says, but I believe you can have a separate wall that exceeds the height of the units by 1 foot. So
Okay.
I need to check the way that that's written in the ordinance. But correct me if I'm wrong, but I believe these are part of the building.
Just to jump in, this board could not do that.
Which part?
The, asking them to make the wall,
Higher than 3 feet.
yes,
Oh, higher than 3 feet.
as articulated. That would more appropriately be in front of planning commission. If this was before, that's not something this board can do. This board is evaluating the standard of practical difficulty, whether or not it meets it. It might not meet it based on the factors available, but it really can't alter these, that require
Standards.
something like that.
Sure.
If this was before planning commission for whatever reason, that
You
could
can make a
maybe be
recommendation to planning, though, that they consider something like that, right?
It could, yes, but
Stand corrected. Thank you. Let me just finish the presentation here. So the last few slides just show some depiction of the proposed building. So this is looking on the site from the northeast, south towards the new home. Just more zoomed in here. This is the carport with immediate access to and from the inside of the building. The detached garage is behind in this image. And then this would be looking from the northwest down onto the site. From the west. And this would be that screening, just a depiction of those horn beams, the hedge, hornbeam hedge, to provide screening along that property line. And then this is the side that faces the golf course. As you can see, it's more of a flat patio area, so there's difficulty with finding appropriate locations for those mechanical equipment. And so then just to kind of put to imagery where we have support from some of the neighboring properties, the yellow smiley faces are the support parcels, and then this is the parcel that has some opposition to the variances that are before the board today. So I'll be happy to take questions.
Do you have any renderings of the garage? You showed some nice pictures of the house.
I don't have renderings of it except for just this elevation here.
Okay. Similar construction and design and colors?
Similar materials, yes,
I
sir.
see.
Yeah.
Okay.
And I assume that rotating the garage would make egress too difficult and...
There's a lot of challenges with, when you look at the dimensions that are given on a site plan or a plot plan, it's easy to kind of imagine some shifts, but when you take into consideration setbacks and the grading contour lines, that's what makes it difficult to make any adjustments. I believe that the initial plan that showed the encroachment of the red area into the setback, it was a greater encroachment, and so the applicant was able to shift it down, scooch it down as best they could, but you run into problems with the grading, and so they wanted to avoid a grading variance before the planning commission. So that's why things kind of just snuggled up to where they are today and kind of locked into place. But we worked with the applicant pretty diligently to get this as the outcome. And so thankfully they were able to get the minimum setbacks along the two sides. It's just that it was a real big challenge, especially with the flat roofs, to get those algebraic analysis, the formulas for both of those sides to work. So.
Can you verify the third bay in the garage will not have a garage door on it?
The plans do depict a garage door, but that's something that the applicant can take into consideration with that question. But
I don't see it on there. Looks like solid walls to me on their storage space.
That's east elevation.
Okay.
It's here though, right? There's a garage door shown here, I believe.
Yes.
Okay.
And how much storage is in the basement of this house, if any? Any idea?
I'd have to pull up the plans, but it's minimal. The lower level is primarily additional bedrooms because the main level is primarily dedicated to dining, living, kitchen, and a master suite. And so the remainder of the bedrooms had to move to the lower level. So I don't have a square footage number for you off the top of my head, but I could pull that up.
So it sounds like that third bay is necessary, perhaps for storage. So.
Yes, that's how we feel about it, because of the size of the house and just the how large we were able to propose the footprint based on the narrowness of the lot. We felt that there was an appropriate need for additional storage space somewhere on the site for the homeowners.
Any more questions for Eric?
No.
All right, thank you.
Sure.
Yeah, any engineering?
Go quickly. As Eric noted, there is no grading changes, so they did build the home to accommodate the current grades. All the retaining walls are under 3 feet, as we previously mentioned. So as far as engineering goes, we really didn't have any concerns. For drainage, I'll just point out that they are proposing a drainage system with a kind of a leaching basin, catch basin in this area. So to take the water and then let it naturally flow onto the roadway. With a basic home and not additional accessory structures or anything, we felt this was appropriate for the proposal that they have provided.
Okay, any questions for the engineer? Thank you. Does the applicant like to make any presentation and supplement to the material produced?
Do you have anything you want to add before I'd like you? No, you can.
Okay. Hi, my name's Greg Fisher. So I'm Kirk here. We started, obviously, a couple years ago trying to plan this project and tried to use a lot of creativity based on the rules. Now, when the lot was platted, setbacks were 20 feet. And there was no such thing as an algebraic equation. And being an engineer, you know, algorithms work in certain ranges, and they work great for square lots and typical lots. It falls apart when you're trying to do something in an odd-shaped lot like this. So we did the best we could to make the house fit the neighborhood in terms of size. We tried to keep the height as low as possible. We have 3 bedrooms downstairs. And then back in February, I went to our neighbors to try to share the plans and walk through the property and show you some of the challenges and what we were going to do. And it became apparent that my neighbor to the east, Charlene, didn't like the air conditioning there because they were outside of her bedroom. Fair enough, I worked with her representative to see if there was a solution forward to find out what other things she didn't like about the projects. As long as I'm trying to fix something, I'll try to fix it all. And the conversation with the representative or lawyer was, if you can solve the air conditioning problem, that is to move them from the east, or from the east side to somewhere else, we can live with the rest of them, in fact, will support it. So, in good faith, I called Eric and Charlie, Mike, the architects, and we got together again to try to figure out a better location for them. And we responded that we just haven't found a good place for them. South just doesn't make sense. It's kind of a walkout area, kids area, golf course, public. Most people, including our neighbors on both sides, have side yard air conditioning units. So there wasn't something immediate that we could figure out what would be the best for us to move that. So I kind of harken back to the price paid for these lots, for golf course lots. They were buildable. Setbacks were manageable. I've done everything we can, thank you Charlie and Mike, to try to get a home in there. And it was important to us that we lived up to what Eric kind of called the spirit of the setback, which was the new setback, which is 34 times 2, or 68 feet, locating an air conditioner from somebody's house. We built an adequate cage, maybe it could be a little taller, certainly fix that. We are 68 to 70 feet from where the concern was. Both the garage and the mechanical units are 68 feet, so we split up. We couldn't attach the garage. Believe me, we're in Michigan. My wife's from California. She would, and your wife is from Florida, would not like to walk across in the snow. We'd like to have an attached garage, but there just was no way to do it with this new algebraic thing that wasn't part of the rules before. I met about a year ago with the head of the subdivision to ask, are there any constraints from there? And met again with them today, and there isn't. Their ordinances are somewhat out of date, and they kind of say if it's good enough for the city, it's probably good enough for us. It's kind of how the way they roll. So it seems like we've done a lot to try to mitigate the problem for Charlene. I don't know what else we can do. I'm certainly open to it. Didn't appear to be any problems with the other variances, just the air conditioning units. And decibel rating on a unit like these, 3-speed, after 50 feet, decibel rating cuts in half. That's assuming no landscaping, no walls, no nothing. So I bet they'll never be heard or seen. And it just seemed like the logical place because we favored the house to the west, and this would be down, so closer to the other house. We favored it away from our neighbor, trying to give her as much space as we thought we could do. We thought we were doing the right thing and wanted to share it, and that's kind of where we stand.
Thank you. Anybody else from the audience like to comment on this? Yes, sir.
Could you do me a favor?
Yep.
Put it on 31.
31.
Thank you.
You can toggle too if you need to.
Oh, okay, thank you.
This is
Please, pointer. Thank you. Good afternoon. My name's Stefan Bagney. I'm from Clark Hill. Normally I have 3 voice levels, normal, courtroom, and coach, but I got a little frog in the throat, so if you can't hear me, please let me know. Our address is 220 Park Street in Birmingham, and I'm here on behalf of Charlene, who lives at 2081 West Valley. The word equity isn't stated in the variance ordinances, but the concepts of equity run throughout them. There's the need to accomplish substantial justice, the need to balance the impacts on the applicants and the neighbors, balance the impacts
on the applicant and the community as reflected in the master plan, and the concept of evaluating whether a problem is self-created. These are all equitable concepts. And the concept of equity never applies when someone creates a particular set of circumstances, knowingly, willingly, voluntarily, creates those circumstances to create a benefit to themselves to which they would not otherwise be entitled. And then they choose to attempt to ignore the ramifications of those decisions to gain a new benefit while retaining the old benefit. And that's exactly what's happening here. This is not equity. The question was raised, how did it get approved, the original house? And the answer is fairly obvious. That's why I asked this to be put up. This was approved as two separately platted lots being treated as a singular lot. We've heard that the setback when this house was created was 20 feet. How do you get a house 2.6 feet away from the property line? Only by treating it as a separate lot, by treating it as a singular lot. There was a conscious decision to build a house that was either too large for this lot or placed in a location not compatible with this lot to gain golf course views. And that decision didn't violate any rules at the time because it was treated as a singular lot to comply with not just the city's ordinances, but also to comply with use restrictions that govern this property.
Councilor, do you have, I'm sorry to interrupt you, but do you have support for that? Do you have proof from the city, the site plan that confirms what you're saying, that it was treated as a singular lot?
I have requested that information to Ms. Burton and I haven't received it. I asked
So
if
you're speculating at this point?
Well, I don't think I think that speculation is not an appropriate word because it's the only logical conclusion that you can reach looking at this drawing. You have the driveway for lot 16 starts on lot 17. You have it 2.6 feet away from the property line. There's only one conclusion that can be reached in looking at this, especially, especially when you look at the substance of those use restrictions. Those use restrictions prohibit any variances for any setbacks. They prohibit any lot from having more than one structure on it. But they allow you to avoid the setback requirements if you have a double lot or a fractional lot. It's right in those it's right in those use restrictions. So this I think is very clearly and obviously treated as a singular lot because otherwise it would be violative of the city's then existing ordinances and violative of the use restrictions that are recorded. And frankly, I don't believe it's our burden to object and present what happened. It's the applicant's burden to explain how they got there. I mean, to put anything on this lot is fundamentally inequitable and fundamentally inappropriate, absent a variance request to allow either a 2.6 foot setback for the existing home, which I am fairly confident doesn't exist anywhere in the city, or to allow, if it's treated as a singular lot, two principal residences on one property, which again, I'm fairly certain, although I haven't researched it, that would be unprecedented in the city. So they're coming here asking to do something which is a non-starter. But then they're compounding the problem by seeking to place the house where they're seeking to place it. we have provided an engineered drawing that establishes that this exact house can fit on this lot if you move it north. They're making a conscious choice to build in the narrowest area of the property, treating it as a entitlement to have golf course views. There's nothing in the variance standards that allows you to have exactly the house that you want on exactly the point of the property that you want it to be. They can build this exact house, just push north and not ask for any variances. It doesn't meet that standard. And that, on top of that,
You mean in the steeper part of the area? Because it's really steep right up to where that house starts.
if my letter, our letter that we provided on Friday, attached to it is a drawing that I can pull out and show to you if you don't have it handy. But it shows that if you put the house in the wide part,
By the road.
let's see if I can do this. If you put the house up here, it fits with no variances. And my client had a civil engineer undertake that analysis to establish that. So how is it that there's a practical difficulty, or it's not a self-created issue because you're choosing to put the house that you don't want to make smaller, or you don't want to have a little bit of replace the glass in part of the backyard. You want all glass on 2 stories in the backyard, and that's why you don't want to have your air conditioner units there. And then on top of that, the ordinance explicitly says if you want to put your air conditioning in the side yard, it can't be in the setback. So it's just this multiplication of inequities that are occurring. None of the standards that apply are met. And it's not substantial justice to compel a property owner to have to go to court to make their neighbor fulfill their promises. They bought this house, or I don't know. I believe Ms. Burton might have said that perhaps the applicant's parents might have built the house. I don't know the history of it. But whoever built this house made the conscious decision to use it as one lot, to build a big, from what I could see from the street and from the neighboring lot, a big, beautiful home that maximizes the golf course views. They made that decision. More power to them. They're free to do that. They didn't violate any rules by doing that. But now they want to keep the house, and they want a second one, which they're not allowed to build. And on top of that, they want variances, which they don't need, to build the exact same structure on that lot. It's just, it is.
Counselor, besides the air conditioning unit, can you tell us how this harms your client?
Well, first of all, maybe this is too lawyerly an answer, but our whole society is premised on the notion that private promises need to be kept, and that there's a societal interest in requiring people to keep their promises, and that if somebody makes a promise, you don't need to go and establish that there's some unusual reason why you want them to keep their promise. They made a promise, they can't put a second house on that. They made a promise, they can't ask for setback variances. They made a promise, they can't ask for detached garages. So respectfully, I don't think we need to demonstrate that. But clearly, the air conditioning is a substantial issue based upon the photos that we provided to you. My client's bedrooms are wall glass. I frankly don't know how she sleeps there, but because it's all glass, all open, all light. And those air conditioning units are being put on her side. I mean, if you were going to put the air conditioning units on the side yard, then put it on the other side of the house so that the people who are creating the problem, since it's the same owner, can endure it.
But Counselor, it's true, isn't it, that the area you just described, she's got a AC unit right outside that window, right?
Well, I don't recall seeing one when I went out.
The generator is the issue. The generator that's going to go off once a week. If there's a power outage, there's going to be a generator by my bedroom when the entire time of the power outage. It's not a matter of 2 air conditioners. It's a matter of that generator unit that's going to be so close to my bedroom.
She can answer the question better than I, because I did walk out and took some photographs, and the photographs don't show any units out there. I don't recall seeing, but I wasn't specifically looking to see if there was an air conditioning unit.
There is one.
I have an air conditioner out there, but an air conditioner is not a generator. It's going to be blasting once a week and then blasting even continuously should there be a power outage. By my bedroom, by my workspace, where I live. I do not even participate in social media, yet I had to share pictures of my bedroom with the entire city of Bloomfield Hills to make my point.
Where's your generator?
The generator that they want to place.
No, your generator. Do you have a generator?
My generator is on the other side of the house by my garage and my kitchen.
And I also just want to walk through that there's a history of treating variances of this nature. And the request here is inconsistent with it. One of them was rejected on 1040 Orchard Ridge. 1820 Rathmore's inside a shed. 265 Lowell Court. There was no place on the property that they could put it without a variance. 852 Canterbury Crescent. The front yard was the rear, and there was already mechanical equipment there. 420 Martell. All they did was replace an existing unit. 150 Lowell Court. It was based upon the location and putting it relative to the location of other existing generators. 30 Scenic Oaks. The alternate location was feasible because there were wetland and elevation on the property, and it was supported by the neighbors. 210 Lone Pine. The location of the pool was limited to the rear yard, and that's why it was put in the front yard. 371 Martell. It was deemed by this body to be the least disruptive or impact on the neighboring owners. 250 Martell had 2 front yards and grade issues. 251 Pine Ridge. The neighbor supported the request before this board, and there were 2 front yards and there was no rear yard, making it impossible to comply. 290 Lone Pine. It was adjacent to the other existing mechanicals. There were no other locations, and there were no objections from the neighbors. So this would be allowing variances in a way that are not contemplated by the ordinance, that are not historically granted, over the opposition of the impacted neighbor on a lot that is unbuildable due to the choices of the people who built the existing house, where there still has not been anybody here who's addressed the very fundamental issues. How do they build on this lot without getting one of the 2 other variances? How is it that I'm finding out on the day of the hearing that it went from 6 to 7 variances, and one of them isn't either a 2.6 setback for the existing house, or alternatively, 2 principal residences on the same lot? I mean, I don't think it would be substantial justice to make our next trip to Pontiac. It just wouldn't be. This should not be granted. If there's no questions.
Thank you. Ms. Sandelman, would you like to say something?
I think it's pretty much said it all, other than my husband bought this house in 1974. He used to go jogging through the neighborhood with George Romney. When I married David in 2003, I put on a back patio. And David spent we spent a lot of time in his back patio. He said, you know, you've created my own little forest. This has been our home. Now with this bedroom here, where I have in my estate plan that I'm going to be cared for in this home, and I'm going to be cared for in a home now that has a generator blasting over there. And I agreed to the other variances only if he moved the generator, which he did not. And he said he couldn't do it, it wasn't possible, which I don't understand. There's a lot of nice houses in Bloomfield Hills and how this wouldn't work any other place. Also, sticking that in between this spot and this spot is just jamming it in. My electrician came to my house to work in my bedroom, and I told him where they're going to put the house. He said, oh, this is just like Birmingham. This is so inequitable. And if they're allowed to do it, they can walk out and they will have profit on this home, they will have profit on this home, and the value of my home will have been decreased. So even if I wanted to move, I couldn't, because I would not be able to sell my home for what it should be worth, because I've got this Michigas here. Now I'm done.
Thank you.
Be happy to move the generator easily. You know, air conditioning units need to be proximity for efficiency. Be happy to figure out a spot that would be away from there, no problem. And to back up, I've only owned the house next door for 2 years. I'm not sure what happened 40 years ago, 45 years ago. But my suspicion is if they wanted to combine the lots to build the house, they would combine the lots, and they didn't. So I don't know.
You know, I can answer this. I'm the neighbor, and
Sir, please identify yourself.
Yeah, I'm Alan Ackerman. I live at 365 next door, and I'm too old to get up right now. And I'm the neighbor, and you know, everyone's envious of me, not because of my success with my kids, but because they all live near me. And Walter Fisher bought that to have this kid in it, and he died, passed away. And I had an interest in buying that house for one of my kids, Fisher House. And Walter told me on all our walks around the block for the last 24 years that he bought the second lot to have his family at the house. And instead, I'm sorry, he doesn't have that opportunity, but his son does. When he bought that house and he bought the lot, he was mad because the Mumsers who did development, whatever those two guys were, who developed Echo Ridge or whatever they called it, they sold off the 2 other lots because he was going to buy 3 lots for all of his kids. And it was in his mind, he got this lot. And he was said, you're the first person who bought that house, my house, that I'm not mad at because you're not connected with my lot, my other lot being lost. This lot was meant to be a separate lot. It was legal, it had the view of the golf course perfectly. And it should have. And it fulfilled all the ordinances at that time, from everything I know. And I wrote this letter without realizing anybody was opposed to the project. If I would have known someone was opposed, I'm not sure. I would have written the letter. I would have hidden out and been invisible. But to hear this commentary that it has to be at the bottom of the, I don't want to build halfway down my hill. I'm next door. Have you ever seen my house? You can see it now that they knocked down all those trees because of some disease. You probably see it now. That is a huge hill there. It's an ugly hill. He's got the longest entry there. If he broke this out perfect, this was designed to be like this, so it would have access for him and for the second lot for his family. And to deny this is just, it would be a shame. You know, you talk about equity here. I mean, I'm going to tell you, if you do this, but for this is someone who is part of the city, this fella here would sue us for inverse condemnation. Your law firm would be handling this because they wouldn't have a lot. That lot at the bottom, moved down that hill, would be a disaster. And it would flood out, by the way, because I know what goes on in some of the houses down the street from us. It wouldn't be built their property. I don't see how you fit any. It looks like it fits and it complies with the ordinance, moving it further north. I just don't think it will physically suffice for the water. And guess what? Have fun knocking down all the trees over there. So that's why I wrote the letter. I'm sorry I wrote the letter. I'm sorry I wasn't at the meeting. I came here because I heard you didn't have a quorum, and you have to come to a decision. These people, in both of these cases, have to decide what they're doing. And that's why I was here to make a quorum today, not to vote. Enough said.
Thank you.
The only thing I would add is that no matter where you put that house, you're going to hear the generator, because the generators are loud I'm sure yours is too.
I know
And you
that.
hear them 3 houses away. So even if it was down further, that would still be an
They're
issue.
still asking for variances. Every variance that's requested is on my side of the house. It's going to affect my side of the house. Last year, my neighbor said, they're doing a tree survey. Do you think they're going to build? I asked Greg, I said, are you going to build? He said, well, we might put something there for our son. We might. And this was last July. Since then, I walked my dogs. Not once did Greg or his wife say anything about building anything there until the variance letter came out. And then, oh, we would love to talk to you about our plans. And we've really taken you into consideration. So I don't care what the original plans were, Mr. Ackerman. Point is, this is just wrong.
And the fact is that how are you approving anything without explaining how you can have a house 2.6 feet from the property line? You can't have that.
Okay, all right. I think you're going to talk about the location of the generator. Is that why you got up?
No, I was just, if there needed to be any visual.
Right. So the applicant indicated that a relocation of the generator might be possible. Are you prepared to, well, can we deal with that now, or does that have to be tabled, or how does that?
Is the west side of the garage a potential place for the generator? Well, that had to have been studied.
Yes, yeah, we could move the generator to a number of locations.
That can be remote almost anywhere.
Yes, one thing we entered into this evening was with the understanding that the air conditioning units was that we're actually presenting more of a problem than the generator. The generator, we have not fully studied every single location that we could place, but the generator could absolutely be moved to a different location.
So why did we have to wait for me to pay all of this money to an attorney to come to this? When this was discussed with him the very first week, I have the screenshots, and he refused to do it. This is so frustrating, and this is so inequitable. And it's definitely bringing down the value of my home by allowing this to go in. I don't care what the intentions were, if this was meant to be. My husband knew Walter Fisher too. I don't care what the intentions were. The point is, we don't know the intentions, and that should not be built there. It's an extreme injustice to me, and it's just plain wrong. They're going to, like I said, they're going to walk away with the profits of 2 homes, and I'm going to walk away with the value of my home going down because of what they've done.
Yeah.
I'm Jessica Stenzel. I'm also here on behalf of Charlene. I understand, like, I have kids. I think that's a really cool thing. Have you explored the options of moving, just because you guys are a family, moving the air conditioning and generator to the west side of the house where it looks like the air conditioning units would still be efficient throughout the house? And if you guys are family, then it would, all the other variances, it seems like there's not really an issue from any parties if that is done.
We have explored that, and if I might be able to speak just for a few moments.
And
Thank you for
who
your
are you
time
again?
this evening. Yeah, I'll introduce myself. Sorry, I've been speaking without giving you my name. I'm Charlie Gatica. I'm here representing Skillform Architects.
Thank you.
We've designed the house that you see before you, and been working with the Fishers closely over slightly more than 2 years on this particular site. So a couple things I wanted to just touch on, and I'll be brief, going back to just sort of the facts of when we began this journey with the Fishers. And the fact of the matter is that this is a situation where we do have 2 separated lots, to the best of my knowledge, in which case, as was discussed at length in the previous presentation before ours, there are pre-existing conditions that are inherent to the lots on neighboring sides that are things that we have been trying to work around and do justice to, but we have not been concerned necessarily with requesting variances for pre-existing conditions that are not on the site in which we have been designing for. Speaking then also to equity and substantial justice, I know we've been discussing, and it's common knowledge now that this house is being designed to be kept within the family. As the architectural firm taking on this project, and in lengthy talks with Greg and Lauren Fisher, we understand that these houses will not necessarily be under common ownership forever. And so part of our approach to the site has been, okay, how do we approach this site, design something that is equitable to a family that may live here one day who is not related to their neighbors,
and how do we then take a look at the site with all of the various factors under consideration. One being that the site was seems to have been originally platted with a property line to the south that abuts the golf course. Every other property, as far as I've been able to tell, along Pine Ridge, along Losher, along Rathmore, that does have a property line abutting the golf course, have built their houses with that in mind, with views to the golf course being something that is a drawing feature to owning a house on one of those parcels of land. So that was obviously a key driving feature of determining where we might want to situate the house. And then additionally, as was pointed out by Mr. was it Ackerman, I believe, the site has also been painstakingly analyzed over the last couple of years by our landscape architect, as well as an arborist. We have a civil engineer on board as well, taking a look at not only the grading of the site, the drainage of the site, the existing mature trees on the site, and as far as I am aware, all of their recommendations for the site was to build the house roughly where we have it situated. There's sort of a natural ridge that exists on the site here. All of the water cascades in either direction. This further north part of the site, I don't have specifics on every single tree that exists there right in front of me at the moment, but there are a significant amount of mature trees on that part of the site that we were trying to retain and not remove from the site in siting the building where we have sited it. And so those were all considerations that we took into place as well. Speaking to whether or not the house could be moved to a different part of the site, I know that there was a civil engineer that I'm not familiar with who provided a plan drawn up on Friday of last week. I cannot comment on that plan in terms of its feasibility. Although I was presented with was a single line drawing taking the footprint of our design and moving it to a different part of the site. I have not seen any documentation that suggests that they have considered the grading and the drainage, nor the actual feasibility of the interior layout of the house that we've designed in terms of moving the house to a different part of the site. So that's something that I don't know is feasible at this time. And it sounds like with anecdotal evidence as well that from a grading and drainage standpoint, that could be significantly detrimental to the site as well. And so that's something that would need significant further study in order to be considered. And I guess to a couple of the other points that were made, the air conditioning units that I think you just brought up, we have considered alternate locations around the house. Again, back to my point of doing substantial justice to future residents of this house, and working around the pre-existing conditions that we had no control over, as the house next door was built before I was born, quite honestly. If we were to move these units to another side of the house, there was a potential in the future that that would do less substantial justice to the neighboring residents who may or may not be related to the people living in the house. And so that's one thing that we took into consideration as well, is how do we place these on the site in a way that is as minimally disruptive to as many of the other property owners as possible. And in various conversations with the city, the owners, everyone involved, this was the location that seemed to make the most sense.
But if, excuse me, just one
No,
second.
they had to do that. They had to do that because this house is three feet from the boundary line. So of course they have to think where they're going to put it, if they want to sell it in the future.
I'm just, sorry, this is just devil's advocate here, but.
Sure.
I don't know if any of this would be approved if there wasn't a family situation, just because I don't think someone would agree to have a house built this close. So I don't know if you can talk about future, because the future owner of this probably wouldn't approve it anyway. I think we kind of have to stay in the present. And
Right,
and just now.
And to that, at that future date, if this were not a common ownership situation, I think we would be having a similar conversation about whether or not we can approve a 4-foot variance to the calculated setback along the west side of the property, given that this lot is nearly 70 feet less wide than it needs to be to meet current ordinances by the city of Bloomfield Hills standards.
I think everyone's just trying to be happy and trying to just just do the best they can. And, you know, I think that would be like an insanely great alternative to place mechanicals on that side with maybe they do the same cool retaining wall with some agriculture around it. And then it seems as if presently, maybe not in future, but presently, everyone would be able to live with each other a little bit.
The concept of substantial justice for future homeowners is an invalid assertion because the burden of placing the air conditioners on the west side would be incurred by the people who are getting the benefit of building this house and who have the benefit of owning a house that is oversized for its lot. And any future buyer of either of those houses will be able to account for that in the price that they pay for it. They will be able to make a knowing decision whether they want to accept that burden or not, as opposed to giving a variance to impose that burden on somebody who was there before on a house that was there before any of this was built.
I got it, Counselor. Thank you. Mr. Fisher, so getting back to your most recent comment about, well, you can consider relocating the generator and maybe the AC. Is that something that, and again, I don't want to propose anything, but is worthy of maybe tabling this current application to allow a revisiting of the plans to prepare some schematics that we can all look at, that the city can review, and maybe Ms. Handelman can get some insight on, and then maybe come back? We're not under any deadlines here, are we, for constructions or?
No.
Okay.
I feel like I specifically heard her say she didn't care about the air conditioners. It's just the generator, and he's clearly said that he can, excuse me, that he can move the generator easily. Well,
and maybe that's considered or not, but I mean, just mechanicals, and I'll put that in air quotes.
Sure.
Mr. Fisher.
Could we just remove the generator and worry about that later? Obviously, we're going to move it, but just remove that from the discussion. Variance?
I don't know that that's appropriate.
In the AC units, I don't know.
So there are 7 separate variances which are before the Zoning Board of Appeal. What could happen is this board could, if it evaluate each sort of in a vacuum, there are 7 separate items technically. The 7th item is the variance regarding the mechanical equipment. And if the board were to deny that variance, the function of that is that they would have to come back with a substantially different application regarding the mechanical equipment. So the function would be they would have to move it. It would not be approved in its current location. It would have to be in a separate location. The alternative to that is tabling this and coming back with an alternative plan. So those are the 2 options.
Well, it seems to me that many of the design decisions that are resulting in the variance requests would potentially be revised depending on where the mechanicals go. I mean, there may be different design considerations that may or may not require these variances. So I don't know if we want to vote on some variances and not the other. It seems to me that this is somewhat interrelated. All these are one beautiful design, but they're all connected. It seems to me.
Well, I guess I'm confused because I hear on one hand the air conditioner being the concern, though you have one near your bedroom, I understand. And then there's the concern of the generator that's loud and then it would run once a week. So if you remove one, it sounds like the other is permissible.
But now, like I said, before I had to spend all this money on litigation, when I tried to speak to Mr. Fisher about this, oh, I can't come up with a problem. Just like when he lied about the fact that he had this thing under works for 2 years and he was thinking about it last July. Now I think the bigger issue, before we even get to any of the variances, I want to find out about this plat here and how this is supposed to be. Is this 2 lots or is this 1? And I think we have to go back to the beginning now. I don't know how we go about doing it, but I don't know how you can look at variances on building when you don't know whether they're going to actually build there based on the location of the primary Fisher home.
Excuse me, Mr. Chairman. For clarity, it is 2 lots.
No,
Lot 17 and lot 16.
I know it's 2 lots.
And just to, for the record, I know there's been a lot of representations. It would not be expected for a neighboring home to request a variance. That is yes, the home is built very close to the lot line, but that's, if you were looking at this and this was not family members who own adjacent lots, it would be as if the neighboring property just, built too close to the lot line. That's what it is. So it would not be, I just wanted to clarify that for the members of the board.
Yeah, I think I understood Council's point. He never said that the lots were combined, and they're not combined. But you raise a point, Councilor, about the driveway being, it is where it is. And so what does that mean for lot 16 and lot 17? Historically, maybe it means nothing. But, so I never took it as his suggesting they're combined. It's just a reality of the property. So, at this point, one comment?
Yeah, one of the conditions in the review letter was that there would need to be a recorded document before any permits were done to allow lot 17 to have its access point on lot 16. The fact that nothing of that nature exists is demonstrative of the fact that it was approved singularly. And I think it's the burden that I hear the whispering about how you need to table it, but I think that the applicant needs to come forward and explain what the history was, because it's self-evident what it was. And you can't build on this lot the way it is, these lots combined, you just can't.
Well,
unless back in 1980, this city gave a variance to allow that to be 2.6 feet, which we don't.
Well, I don't know that, and I'll defer to city attorney, but I don't know that the existence of an ingress-egress easement is necessary right now in this stage of the process for the proposed development. Certainly at some point it would be, but whether it requires it now, I don't know that we're here to.
I can clarify that we have discussed that with Eric in the meetings that we have had over the course of designing this. And we have discussed with the Fishers that if we want to continue to provide single point access to both lots, that they would happily provide an easement and sign off on that at a future date once there was actually construction plans for an additional residence to be constructed on the lot.
Right. There's no landlocking here, so there could be separate ingress-egress for each lot or an easement. I don't think that is dispositive here. But so we're at the point of we're either going to consider the pending application and the 7 variances, or the applicant, if through some consideration of revising the plan, relocate the mechanicals, and we can come back another day. Is that what the pleasure of the applicant is?
I will relocate the mechanicals if we can decide on the other variances. I will relocate them to the west.
Well, are other aspects of the application capable of being independently approved with assurances that they're not going to have to be redone again if the mechanicals require some different design?
So the mechanicals in the right are on the east side, in the east side setback. There was discussion about potentially shifting them in the location that they are on the east side. But the problem that we ran into with those conversations is that the change in the grade may be impactful enough to where there would be concerns for having a variance for the grading changes. So I don't believe by relocating the mechanicals to the west side of the house would have that same impact. But that's just something that we had to take into consideration, that by relocating those, does it open the door to any other concerns? As far as I'm aware, I don't believe so. Looking at it just strictly dimensionally, I don't know if from the engineering standpoint, if there would be any alterations to grading on the west side of the house to accommodate units there. So that might be the justification for tabling the item to make that analysis, unless that's already been done. It's not to my knowledge that it has, so.
We have not done it to the extent that would be required for a decision to be made this evening, I don't believe.
Well, so it's translated so I can understand it. Are you saying that just variance request number 7 would be potentially tabled, and items 1 through 6 could be considered today in light of the reconsideration of the mechanicals and what that may or may not do to the rest of the issues.
I think the two if I'm understanding Eric correctly, as well as my kind of own instinct on this, the two options would be to table the entirety, so all 7, to conduct an analysis on whether moving the equipment to the proposed location would impact other variances. I believe Eric does not believe it would, but no thorough analysis has been done. So there is a nightmare scenario where they do it and then they need to come back for 3 more variances. Or the board could, treat the first 6 as the proposal and deny the 7th. But the result of that would be that they could not come back with, it would be prohibited. Placing the mechanical equipment in the current proposed location would be prohibited. So even if there was an issue with them moving it, that is not known because an analysis has not been done, they could not propose the current location. Does that make sense?
But if the entire application, all 7 topics were tabled,
yes,
right, that would preclude any reconfiguration, any resubmission of different variance requests as may or may not be necessary, right? There's nothing that would preclude the reconsideration by this board of all the topics.
Correct.
Is currently proposed and may be modified.
Correct.
Okay. Mr. Fisher, is that something that
So
you're requesting?
say that one more time.
Yeah, can I interrupt?
Sure.
Can we approve certain ones and then defer on the final one that you're referring to? Just
Like-
defer?
I think that's what.
As opposed to saying no, you just defer and we get more information.
Well, that's tabling. So there's no vote on any of the variance
Well,
requests.
but I'm asking if you could vote for some is what I'm trying to
So
find out. The last one's the sticky point.
The reason why we wouldn't want to do that, and I'm sorry if I'm talking around it, is by moving this mechanical equipment, it's possible, not likely, but possible, that additional setbacks, there might be additional variances that would be impacted, like additional maybe grading, maybe there's a setback that isn't contemplated on the current plan. So instead of tabling that, and it might impact 1 through 6, which would be approved. So instead of raising that possibility, tabling all of the items and allowing for this analysis of moving the mechanical equipment would probably be the best option.
How did we get away from the point that, I mean, at one point we were at, okay, it's all okay except for the generator. Now we're back to the air conditioners again when it was already stated that the air conditioners were okay.
The applicant just offered to move them all to the west side.
Well, after this conversation,
If we were able to move them, they were gonna support all the variances.
No, that was initially, that was when all of this started, before I had to go and hire an attorney and pay all of these fees, when I said, if
okay,
you.
well, I didn't mean to open a can of worms, but are you not happy with agreeable to the?
No, right now,
Just a
I will not
second.
do any of these variances. I'll take it, I'll go to the next court. There's just no, I'm not. I want to know what's going on with the plat. I know what you're telling me, but I don't know if you have sufficient history on that. I want to understand what's happening, and I will not agree to anything. I will be ready to move on to the next level of litigation. This whole thing smells to me.
Well, Mr. Fisher, this is your application, sir. So you've heard where we're at right now, and I, speaking for myself, would leave it to you. Would it be your pleasure to, at this point, table the pending variance requests to another day to allow you to convene with your consultants and consider, subject to Ms. Handelman's statements, but consider revising the proposed plan in a way that maybe you can discuss with Ms. Handelman and her counsel, a reconfiguration that maybe finds more a more receptive audience with your neighbor?
Are you talking about the whole thing, or?
Well, I mean, I would start with just the mechanicals and see how
We
that,
absolutely will commit to moving air conditioning units and generator, both.
and
To the west side of the house, outside of, to the kind of north end of the house, it's flat. We can talk about that there's gonna be 2 or 3 more variances, there's not. It's very,
Can you pull that area up on the screen?
yeah.
Ariel?
Why didn't he,
yeah, so why
why
don't,
the other 6 approved?
well, so why don't you go back to the drawing board, do that,
No, the
and
drawing,
since there's no prejudice to
or a,
your project, it seems to me, let's take them all at the same time as
This one?
revised. Is
Yeah.
that something that works for you?
I'm so sorry to jump in, Mr. Chairman. As long as it's clear that this item is tabled, the other 6 are not, nothing would be approved. It would be, all of the items would be tabled for reconfiguration. And then this board would rehear the entirety at the next meeting.
Yeah, I think that's what we have to do.
I just, for the applicant's benefit, I just wanted to make that clear.
I would just like a vote, that's all.
Well, if we're tabling it, there's no vote.
I would like a vote, that's what I'm asking.
Oh, okay. All right, so so there's any more comments from the audience? Hearing none, at this point, do I have a motion? We've got 7 different variance applications. We can go down the list, or the city attorney has made a proposed motions, and if someone would like to make a motion.
I make a motion that we table this.
all of them?
City attorney, is that something that the ZBA can do?
The ZBA can table items. Traditionally, the applicant requests that.
But that's per ordinance, we can approve, deny, approve with conditions, or table?
Correct. That is something that can be done. That is something that can be done.
All right, I've got a motion to table. Is there a second?
Second, that's tabling everything, correct? Okay.
I got a second. All in favor of tabling, say aye.
Aye.
Any opposed?
Nay?
So that's
3 noes?
3 noes and 3 yeses.
Right.
Is
Well,
the
then the
city
motion
manager-
fails.
Can
Motion
you,
fails.
can the, oh, okay.
So we've got a quorum.
Yes.
So if we've got, well, so what happens now with a failed motion to table?
So, that is not, the motion to table this matter has failed, therefore the board should consider approval or denial.
Well, is there a motion of approval or denial?
I would be happy to move that we approve the project.
Support?
All in favor?
Aye.
Aye.
Any opposed?
I abstain.
So motion passes.
Correct.
All right, Mr. Fisher, you've got your.
You were supposed to read it.
Oh,
Wasn't read.
yeah. This was your motion? You've got to read, let's read this into the record.
Yep.
I move to approve the 7 variances listed on page 1 of the ZBA review letter from sections 24 to 196, 24 to 196V, and 24 to 229A2, in order to allow for a variance from the minimum side yard setbacks and the calculated side yard setbacks in order to permit the construction of a new home and allow for a detached garage to be located in the front yard. I further move to approve a variance from section 24-229B11 to permit the location of mechanical equipment in the side yard. The applicant has demonstrated practical difficulty for the following reasons. Can I read the whole thing?
Yeah.
Okay. Number 1, strict compliance with the requirements would unreasonably prevent or severely limit the owner from building a home on the property and placing needed mechanical equipment in a reasonable location on the lot. Their narrowness of the lot makes placing a detached garage in the front yard the most reasonable, low-impact place to site such an accessory structure. Accessory structure. The lot is exceptionally narrow and does not adhere to the minimum requirements for lot width in the A2 district, and these deviations permit the property owner to build on the lot. Number 2, the requested variances would do substantial justice to the property owner as well as other property owners, as it would permit a home consistent with the other homes in the neighborhood in terms of size, quality, and orientation to surrounding amenities. The property owner has worked with the city very hard to reduce the size of the variances requested, while also designing a home in keeping with the style of the neighborhood and placing the needed mechanical equipment in the most reasonable location for the orientation of the home. Number 3, the plight of the property owner is due to the uniqueness of the property. The lot in question is only 164 feet at its widest point and only 104 feet at the point where the home is proposed to be built. There is limited space for the mechanical equipment in the detached garage, necessitating these variances. Number 4, the proponent's problem is not self-created in that the property is uniquely shaped and far more narrow than other lots in the same neighborhood. Number 5, the granting of the variances will not adversely affect the purposes or objectives of the master plan. The purpose of the master plan in residential areas is to allow homeowners the opportunity to improve the property while minimizing impact on the neighbors. Motion to deny the variance as... No. Oh, sorry, that's the next one. Yes. Sorry.
So, do I have it, now that she's read that into the record, is there a second to that?
The motion has been made, seconded, and passed.
Okay, and so this is just a supplement to the
Correct.
motion? Okay, so we don't need any further action?
Correct.
And for clarity, let me just make it clear, I'm not related, independent, to the applicant, just in case.
But I am taking this further. This is not going to stop here.
Can we make any other comments, Mr. Chairman?
No, I think that matter has already been considered and voted on and addressed, and that concludes the agenda for tonight. Thank you, everyone, for attending.